Okay, welcome, folks. This is House Corrections and Institutions Committee. It is Tuesday, April 22nd. We've now shifted gears again. We're working on H379, which is a bill that pertains to second look in terms of a person's sentence. And after 15 years, to take another look at the length of that sentence, and the court may adjust the remainder of that sentence. So it would be good to talk to DOC to see how this would break down in DOC, how many folks, what sentences folks have, what they've been convicted of, the length of sentences. Do we have life sentences? Do we have life sentence parole, without parole, in our structure, and how many folks might qualify for this? Isaac, yours.
Okay, thank you, Chair. For the record, Isaac Dana, I'm the policy director at the department. As with most things, I'm kind of a mile wide, inch deep. So I've brought some of our subject matter experts from the department. Britton Pasha, our classification director. Haley is always here. And then also Jess King Moore, who's our director of data and research for the department, who's joining via Zoom. Great. So I think we're going to run through some slides very quickly. And I think, I just wanted to lay out there that it's okay if folks are a little bit confused about the variety of legal statuses in Vermont. This is a report from the Council of State Governments a few years ago as part of the Justice Reinvestment 2 initiative. This is from their final report. More than 30 different legal statuses. We've cleaned some of these up in the interim, but many of them are still on the books. And so I just want to kind of point out this is a pretty complicated system. So I know we're not talking about a new legal status here. It's more of a legal pathway petition process. But just wanted to kind of put out the scope of the different legal statuses that exist in Vermont. And this is where I will rely heavily on our subject matter experts, looking at Pasha here. If folks have questions on any of these and want to dive in deeper, I'm sure also subsequent witnesses will be able to give you more testimony.
And this is the material you have on the website.
Yes, yep.
So the real focus for us in looking at this would be more the furlough, the reentry furlough, as well as the parole piece. That's where we really need to look at. So, and some of the furlough, we've taken some of that out, like conditional reentry. Did we take that out, or reintegration? We kind of condensed that.
We have also added to this as folks are with like pretrial supervision and things of that nature. So it is
a change, and we don't have home confinement anymore.
Right.
That's gone.
You still have home detention though.
Yeah, we have home detention, but that's free. That's right. So we do have medical furlough.
Right. And if we actually go on to the next slide, Haley.
Parole before, yeah, okay.
I kind of want to neck this down to just some of the current, framework that we have right now for folks to release to the community. So furlough, medical furlough, parole, presumptive parole, PCRs, probation, if there's kind of a split to serve, someone might exit for that. This is more the field supervision side of things, but mid-review to discharge someone from probation. And then also thinking about the 70% rule for certain high-risk sex offenders as well, that they have to serve 70% of their maximum sentence before they're eligible for release. So I just want to give you a sense of the universe here. There's a lot of different mechanisms at play currently in statute.
So Sean and then James.
I just was going to ask Judge Sone if he agreed with that sentence from the last slide.
What sentence?
That work crew is back?
No. Go back one slide.
What sentence?
Vermont's legal system for incarcerating and supervising people in the community is undermined by its complexity and definition of furlough as an extension of incarceration. Do you agree?
Furlough is not part of the courts.
I was just wondering, it's not.
It's DOC.
So that's not under your deal.
Well, there are some furloughs that the court can sentence directly to. Pre-approved furlough for certain ISAP, for instance, intensive substance abuse program. The court also is involved in the DOC treatment furloughs. We have to get permission for that statutorily, but beyond that, furloughs do fall under the authority of the Department of Corrections.
Okay,
the only
gotcha.
thing that falls under the court is probation and home detention in terms of whether someone goes to home detention or not. But furlough and parole are under DOC. That was DOC 101 back in January.
Yeah, well, good luck with that.
And this is DOC like 801, but I think, to that question, this is a set of recommendations made by CSG. So this is not the department endorsing those recommendations. I've linked it here in the title. You can click through and read the document for yourself.
Thanks, Isaac.
James?
The others, yeah, the 3-second version, not the long one. What's presumptive parole?
Written into statute that essentially, this is my understanding, and feel free to
We're
correct me.
presumed to be paroled.
Right, you're basically, if you meet a certain set of eligibility criteria as
Your
laid
minimum.
forth in statute.
It's your minimum. This is a way to move people through the system. And we've put this in place a few years ago. It's a slow rollout. At your min, you are eligible for furlough. Doesn't mean you're gonna get it. You are eligible for furlough at your min.
Mhm.
And in working with CSG and all of this, they said, if you could just go right into parole instead of dealing with this middle piece. So at your min, you are presumed to be paroled. But the department can say, this is not a good candidate for parole at this point. But that goes before the parole board. Parole is through the parole board. Furlough is through DOC. So for folks who reach their min, they are presumed to be paroled, but DOC can petition or connect with the parole board and
Alright.
say, this is not a good case for parole.
Onus is on the state.
I got you. I mean, it's close enough for what I need. Thanks.
Kevin,
Since you got the ball rolling, can you give an example of post-conviction relief and probation split to serve? I don't know.
I can cover probation split.
just identify yourself, please.
Yes, sorry, Jordan Pasha, Director of Classification. So a split to serve is, the court will say you're sentenced to 10 years, all suspended, but 6 years. So you serve 6 years incarcerated and you serve the last 4 on probation. Post-conviction relief, I don't know much about. I apologize.
Let's hand that one over.
Surprised that it's on the list.
Is it even still in place?
Of course, but I don't think it has anything to do with this. I'm Matt Valerio, Defender General.
Mhm.
I don't know why it's there, but
Where does it come from? Is it the courts or is it's the courts?
well, we have to file, it's a lawsuit. We file a lawsuit. Prisoners' Rights Office files a lawsuit, or the appellate division now, and says that there's something wrong with the original trial. So there was ineffective assistance of counsel. There was malfeasance by law enforcement. There were newly discovered evidence. There's juror tampering. There is juror pollution. There is something that went on during the trial that would allow the person to have the conviction or sentence vacated. And then you go back and you could potentially resolve the case by settling it and, maybe it's released, but it's not, it doesn't look or smell like any of the other things on the list.
Good feedback.
It's a totally different.
It's not like the other thing.
Thank you. I understand.
Like, we just wanted to put kind of the full universe of some of this stuff up there just to get the committee aware.
There's a lot of off ramps.
And if we could go to the next slide and get into.
Also, parole does have medical parole. There's also medical parole as well, not just medical furlough.
And medical furlough, I will say, we exercise as a department. It's relatively common for extreme cases where someone is very sick, and so you might actually see that in some of the press releases that you get from either Haley or myself. You might see that someone was on medical furlough at the time of their passing. Our departmental policy is if someone is on medical furlough and they pass within 30 days of that decision, we'll alert the public to that and send it out as if it were a death in custody.
I jump in.
Yeah.
Another common use of medical furlough is when we have individuals who are aging, they're declining cognitively or physically, have chronic medical issues. We'll refer them to the Choices for Care program, where they'll be evaluated for clinical and financial eligibility. Should they meet that eligibility and be pre-min, we can recommend them for medical furlough, and they'll be furloughed to a long-term care center.
And that's pre-min. You
It can
do-
be pre-min, it can be post-min.
Okay.
If it's pre-min, it requires medical furlough.
Great. So we just want to provide the committee with some data around cost. I think we've talked about this before, but $299 is sort of the current rate that the department uses to estimate cost. We asked our data team to look at the individuals in custody as of today who have served at least 15 years. Folks currently incarcerated, it's 104. Looking at the sentences here, folks who have, as of today, a minimum sentence of at least 15 years is 147. Folks with a maximum sentence of at least 15 years, 295. Life with parole, 119. That's a bit of an estimate from our team. And then life without parole, 11 individuals.
Connor, then Troy.
Yeah, sorry, Isaac, you've been through this before, but I keep getting asked, is it a 299 number? What's the equation that gets to that, right? Is it like
Right.
pensions? Is it like, book and caboodle?
Because it's
Yeah.
not actually, it's not actually about the care of the person. It includes a lot.
Right, all
of-
the
Right.
costs of running the facilities. Yeah,
So the
I think we,
book and caboodle divided by number in the facility?
I think a rough, crude estimate, but
Gotcha.
that's what we use right now.
Troy.
Just want to make sure I have this information correct. So minimum, folks serving with a minimum of at least 15 is 147. 104 of those have already served 15.
Yes, that would be my understanding.
And then anybody with a maximum of at least 15 wouldn't be impacted by this legislation. Does that feel accurate?
Well, I think. I think this is a maximum of at least 15 years. So you could have a 15-year sentence, but your max, or a 14-year sentence, but your maximum could be, I don't know, 100 years or something. So you wouldn't be captured in that first number, but you would be captured in the second number.
So that 147 could be captured in the 295.
The 295, I think, is like the larger denominator.
Okay, I'm with you. Okay.
And, I think obviously the 295 is the larger one. So you could have folks who, have served their minimum of, but have not yet reached their maximum. And that might be because, for whatever reason, they could, for example, not have completed the required programming that they need to make be eligible for release.
And why is LWP an estimate? Because
Because I think we don't have technically a life with parole sentence. And so that was us estimating it based on their sentence length. If someone's minimum is like 2150 or something like that, but they're still eligible for parole.
So we have folks that carry no sentence of life with parole.
I don't think we technically have a life with parole sentence, right? But by giving someone a minimum sentence date of something, 100 years in the future, it's essentially a life with parole, but they're still eligible. And then the 11 cases here on the LWOPs, the life without parole, those are kind of the very high profile crimes that you've probably seen, in the papers over the years. That's a smaller population.
Huh?
Do you have a sense of the average age for those 11?
Question, we could find out.
Okay, yeah, that'd be helpful, actually.
So life without parole, there's no minimum. There's no minimum with a life without parole, just straight through. And do you have how long those, well, it's life without parole, it's life. And do you have the numbers for how long they've been in there of
Well,
those
that's a-
11?
The age.
No, off the top of our heads, but we can get that for you.
Some of them are older, much older cases. Some might be more recent. It's probably a spread.
Just a quick one. So here's the different jurisdictions that have different definitions of what life is, right? So I throw out numbers, none of them will be right, so I won't, but it's not until you die usually. Like it can be that long, but what is our life without parole? Like, is it 56 years, 40, 65, or is it literally you?
It's life,
It's
depending what age you're.
literally
Till you die in life.
You could come in at 20 with life without parole, you're there your whole life. Or you could come in at 70 with life without. It's just your life, it's now gonna be lived out in incarcerated setting. So we have 11 of those folks. It'd be interesting to know when they came in. And what would be the crimes usually? Maybe that's more of a question for the judiciary. What would be the crimes for life without parole that they would be sentenced?
I mean, I know there are a couple.
Aggravated murder, first degree,
Mhm.
aggravated sexual assault, potentially. I don't know if there are any of those, but there was at one point. I mean, it's only another.
It's only 11.
Right.
People.
Thinking of the case up in Enosburg lately, I think one of the charges was aggravated murder.
Yeah, I'm familiar with a couple that are riding their way through the PCR process.
Right.
Through what process?
PCR process, post-conviction
Post-conviction.
relief process, which is almost a guarantee for every single one of them. Which will be part of what. Talk about.
So I put it on the slide.
Sean, did you?
No, I'm all set.
This
Are
is
those-
Jess Kingmore on Zoom, Director of Research. Oh, yep, I see myself on the screen. It's fine. But anyway, I can answer some of your questions. I have the spreadsheet pulled up. So,
Right.
yeah, so I can kind of help. So median age was 54 for the life without parole individuals.
Is that when they were sentenced?
No, current.
Current age,
Yeah, yeah.
current median 57?
Four.
Four, I believe. Let me check. Yeah, 54 is the median, but we have the range is anywhere from 43 to 82 currently.
So
Would you have, Jess, would you have a percentage of 11 seems like a low number to me? And is that low like the rest of the states? Are we low? Are we average like with the rest of the states?
Question for, Dr. Reese. Yeah, you're low.
Did you,
So you
Dr.
have-
Reese,
you
could you,
Hi, Bershani Reese, Dr. Bershani Reese. Yes, so Vermont has the lowest number of persons serving life without the possibility of parole in the 6 New England states.
Lowest number or lowest percentage of?
Lowest number. Your next lowest would be Rhode Island, who has 30.
Mr. Reese.
so are these 11, are some of them down in Mississippi? Or I would assume some have such health issues, they may be here in Vermont, but it's any of the 11 down in Mississippi?
Yes, actually quite a few. 6.
So half,
Mm-hmm. And for sentence dates, they span from 1990 to 2017.
How many are women?
2.
Know that
Got
one
it.
off the top of your head, and that is true. That's what I have too.
She couldn't help herself.
I apologize.
anything else on this one before we keep going, or is that all you got?
That's all we got. I see a lot of folks, some confused faces, so everyone good?
we're good.
What's the confusion on? Now's the time to ask.
Okay.
So the bill for second look pertains to life without parole? Folks?
Mhm.
So in Vermont, we'd be dealing with 11 folks. And how many? That's the whole system, all 11, the whole system.
Mhm.
Have you told us what the charges were for these 11?
Yeah.
Not sure.
The convictions.
Just we have their conviction.
Convictions.
Convictions are different than
You should-
charges.
Yeah, I'm sorry,
Murder.
convictions.
Aggravated
that's
murder.
really-
It would be those high profile.
Do you have that, Jess, at all, what their convictions were?
Yes, I have to, it'll take me just a second because I don't know all the acronyms off the top of my head. I'm checking our code book, but give me 1 second.
Thank you.
They're an acronym, especially.
Statute.
Well, Chair, you just said this bill is pertaining to life without parole, but it's pertaining to a bunch of other sentences too, right? Okay, yeah.
Your day one impact would be 104. If I'm understanding Isaac's numbers correctly. That would be your day one.
Say that again.
Your day one impact in terms of like when the bill goes into effect, how many people are eligible. It would be 104, and then it looks like there's growth there for another 100 or so individuals.
If they've served at least 15 years.
And do you have access to information to know of those 104 who would be recommended for second chance?
I don't because,
Because it's not available to you, right?
yeah, and somebody would definitely need to put together a robust, package of all their programs, their records.
Yeah.
Yeah.
I didn't think your answer would be yes, but
Yes.
if you did,
I would definitely give it to you.
So the way that second look would be triggered is that the DOC could petition the court. The incarcerated person that's eligible could petition the court. The prosecutor, the Office of the Defender General, and the court itself. So there would be a petition filed with the court to begin proceedings in terms of second look. And it is the court that would determine if that initial sentence is adjusted. DOC would not do any of that because it's not in DOC's jurisdiction. The sentence is not in DOC's jurisdiction. The sentence is in the courts, the judiciary. So Jess, are you still working on that?
We might be able to pull up the statutes as well that.
I have it for just specifically these individuals. So
So you're
this
talking
is
about the 11?
yes.
yes. These are their most severe crime, because I just have that readily accessible. There might be multiple counts of these crimes, and there are typically more than just this, but this would be like the major crime that's like leading this charge. There were 5 with murder, 2 with
5 with-
aggravated. Yes, murder. 2 with
5 with aggravated murder?
5 with just murder, 2 with aggravated murder, 2 with kidnapping, and 1 with aggravated assault. And again, there could be multiple counts. There was one that Isaac and I looked into where it was a quadruple homicide, right, for one of these individuals. So there could be multiple counts of any of these things, as well as other crimes on their MIT, but this is just the most severe.
So Kevin, did you have something else? Or was that it?
Well, this Kevin did.
I knew somebody did.
This is probably a Dr. Reese question. I'm wondering if, as opposed to time served, like a minimum of 15 years, if the inmate's age is ever taken into account as a way of release, if you're 21 and you've served 15, because I'm thinking about your graph where your chance of reoffending bottoms out at 45 or 50 or whatever.
Absolutely, because of what you just said,
Right.
connecting age to risk.
Right.
So if the person went in at 20 and they've done 15 years and they're only 35,
Right.
you may want to hold that person a little longer, given the aging out of crime factor. But if somebody was 25 and they've done 20 years, and now they're 45,
Right.
safer to release.
But that's not necessarily part of the legislation, that's part of the review process.
Absolutely.
Yeah.
It's meant to be case by case.
Okay.
It's the 15 years triggers it. It
Correct.
doesn't mean the person's going to
Right.
automatically release.
Mhm.
Just triggers it. Kevin?
Another question, which I would imagine the answer is no.
Yeah.
Do we have any estimate as to what it will cost per person to go through the process?
I would love to hear from the state's attorneys. I think they're the expert on the cost on their end.
And it may be a ridiculous question at this point, but with other state experience, I was hoping maybe there was, on average, it's.
I can do a little more research on it. I know that each state who has handled Second Look has handled it in vast quantities, far greater than Vermont ever would have to. And so I think they've funded it through a variety of ways, including like having pro bono student attorney clinics, for instance, like represent people going through the process, so there's no expense to the taxpayer, that type of stuff, but I'm happy to look further into it.
But even that would be helpful information because
Of course.
Vermont is a state where there might be plenty of pro bono work, so
Yes,
that would be fascinating, if not totally helpful.
absolutely.
Other questions of DOC? Anything else, Isaac? You want to share? You dare? Okay. So according to the bill, it's on page 3 of the bill.
Yeah.
It is the court, it is DOC that would provide written notice of the Second Look Sentencing Act to the incarcerated person sentencing court, prosecutor's office, or office of defender general. So the person would have to have served 15 years of imprisonment, and not more than 3 months after that date has been received, DOC would provide written notice. Okay?
Mhm.
So the petition needs to be filed with the court, and it's with the sentencing court. And then it is the court that makes the decision. So we have both Judge Zone here and also Matt Valerio for the sentence, for the Defender General. So we want to kind of see how this would work in terms of receiving something from DOC, what then you see it playing out. Should it only be DOC that petitions the court, or should there be other folks involved as well? So I don't know who wants to go first. It should be the judge or the Defender General. That is so good.
Very generous.
Good afternoon, Tom Zone, Chief Superior Judge. So I kind of ran through the bill, if that's okay, and I'll just go through, because what would happen is the department would notify someone, and they may have been, I would suspect that most individuals, if this bill were to be placed into effect and become law, would have an idea about this coming up after 15 years. So DOC would notify them, and then potentially things would be filed. And so if it's okay, I'll just go through some of the concerns of how things are structured in the bill for how it moves forward. Whether or not to have this as a policy, obviously, I won't weigh in on the policy of it. But the impact of how it goes forward on the courts is something that I think is critical to understand as you look at this. So on page 3 of the bill, on lines 15 through 17, this starts to talk about the petition itself, because that's the process that will come to the court to start things moving forward. It talks about including affidavits, declarations, and other documents, but there doesn't seem to be any real, if you will, purpose for that at this time. And I'll talk about that later, because the parties have the opportunity to file things later, and the only criteria for being able to file this petition is you have a sentence of at least 15 years and you've served 15 years. There's no rehabilitative criteria. The DOC doesn't have to agree that someone should have their sentence reviewed. That's the only criteria. And so when you look at that, and you have all these things being filed up front, it's unclear what the necessity of that is, other than to put someone on notice of here's what I think and here's why it should happen. The next thing on line 21, and the petition can be filed by someone
on behalf of the inmate. And they have to tell their relationship. And so the question I have is there any guidance? What does the court do if you have the petitioner's mother and wife both file one the same day? Whose do we take? In other words, there's nothing here that says how someone can do it. What happens if the inmate says, I don't want you to file on my behalf, as opposed to an inmate who says, please file this, I can't. And so I think that's something to consider. If you're going to give someone a right to file with no criteria, I do anticipate that there may be the potential for more than one filing on an individual and competing interests there. On page 4, on lines 14 through 16, it provides that it goes back to the original judge, unless the petitioner requests otherwise. That's something new in Vermont, that a defendant has the opportunity to say they don't want the certain judge to sentence them again. Unaware of the genesis of that, but that's something that is certainly different. Realistically, if you look at the age and time of judges on the bench, you're probably not going to have the original sentencing judge. So as a practical matter, it might not be something, but I've been on the bench in year 19 now. So theoretically, this could come back to me. And so that can happen at different times with judges. But again, I don't know the policy behind allowing the petitioner to say they don't want a certain judge, because what would happen then is it would fall to the chief superior judge, myself or my successor, to decide who gets the case. Just below that, on page 4, it says that on line 17 and 18, if the court determines that the facts stated in the petition are insufficient, the court may provide an opportunity to amend. But again, the only fact that someone has to establish is actually 2 facts. Their sentence was at least 15 years, and they've served 15 years. So I don't really know what other facts they would need to amend at this point in the petition, because that is the key to being able to move forward. That's the threshold. On page 5, line 6 through 8 says, notwithstanding any provision of this section to the contrary. It's unclear whether it's referring to the section as the statute as a whole, whether it's referring to a subsection, and it's not quite clear what that really means. An otherwise eligible incarcerated person or petitioner shall be eligible to file a petition upon consent of the prosecution. The prosecutor. Well, they don't need permission from the prosecutor to file after 15 years. Does this mean that they don't have to follow the 15 years?
I need just a few seconds with that one. Hold on. Oh, because of the notwithstanding?
Yes.
Yeah. Okay.
So it's unclear what that means. Lines 9 through 11, neither statutory mandatory minimums nor fully executed plea agreements shall preclude an incarcerated person or petitioner from seeking relief under this section. Operative word being seeking. This is a resentencing. If you came before me on a resentencing and we have a mandatory minimum sentence to impose, we still have a mandatory minimum sentence to impose. This doesn't say that it trumps every mandatory minimum, because think of it. What this would effectively do, in certain sex offense cases, you have 25-year mandatory minimums. This bill, if the intent here is to say the mandatory minimum doesn't matter, you effectively have a 15-year time span for those mandatory minimums, and then there's the potential for them to be vacated by the court. And so the other question comes up is, what about life on the maximum end? This doesn't affect any maximum sentences, and there's a number of sentences that it's required for the court to still impose a life sentence. On lines 12 through 14, if the court determines the facts stated in the petition establish eligibility for resentencing, the court shall schedule a hearing. But as I've said, eligibility is a very basic premise. So we're essentially scheduling a hearing on these cases. Line 15 through 17, it says we have to hold a hearing within 45 days if certain criteria is established. We're currently scheduling out 4 to 6 months in many of our cases. And so when this is filed, we'd have to move other cases in order to be able to accommodate that. It also has medical conditions and such as the criteria for the court to determine as to whether to have this on a expedited basis. Does the state have an opportunity, or the Department of Corrections have an opportunity to say, no, that representation about the medical condition is not correct? They don't get the 45 days. In other words, it's unclear whether the court has to accept something at face value, and what we do if another party to the action, if the state, for instance, says, well, those facts are not true. So there's no process provided for that in the event of a dispute as to those issues. On page 7, lines 4 and 5, it again says, if the petition does not meet the criteria, but again, the criteria is very basic. The criteria is the 15 years, but it says made under this section, and the individual has served not less than 25 years, and the incarcerated individual is not less than 60 years. It's unclear what this is referring to. Is it just referring to the timing of the hearing, in which case it's really referring to a prior subsection, not the entire statute? So that language is unclear. Same page, lines 8 through 10. It's the same thing. If the petition does not meet the criteria, and it keeps saying that, and again, the criteria is so basic, I don't know why it would need to be repeated constantly throughout the statute. On lines 12 and 13, it says, upon request of the petitioner or prosecutor, the court shall hold a hearing where the parties are given an opportunity to present an argument. But as I said earlier, they've already been told, we've already been told as the court, we have to hold a hearing, even without request. And so there's an inconsistency there. One section says we shall hold a hearing, another section says that upon request. It's also unclear here, the parties shall be given an opportunity to present an argument in support of or against the petition. Now, remember earlier when I mentioned about the filings, nothing is in here about what the parties get to file. And so is the petitioner bound by whatever they filed up front? And if they try to file something a week later, the answer is no. Does the state have the opportunity to make filings? Or is it going to fall to the court's discretion to say how we're going to handle that? But the lack of clarity there could lead for differing conclusions in differing courts. It does talk about the court at its discretion permitting the parties to present evidence that the court deems relevant to the petition. And that could include testimony affidavit. So it's unclear whether that's upfront, whether we can say, okay, you're just going to have oral argument, file everything ahead of time, or we have to give a hearing at the time. On page 8, line 2, it says the court shall issue a decision detailing its decision. Detailing is not a phrase that we generally would use in the courts. The court issues a decision, and the order itself is what we need to make sure it contains our determinations. But detailing its decision, it's unclear what that means, because is it intended to mean something different than what we normally do when we issue a decision and rule in a case? It also says on page 8, lines 4 and 5, that the court shall consider factors including relevant research regarding development of youth brain, and lines 6 and 7, relevant research regarding the decline in criminal behavior as individuals age. Do we all agree on what that relevant research is?
No.
Do we know where we get it? Courts don't go out and find the relevant research ourselves. Judges rule on cases that are brought to us. Who's responsible for providing us the relevant research? What happens when the state and petitioner disagree on the relevant research? Do we then have hearings to determine whether or not they have established things? Do we then have to have Daubert hearings on whether or not the expert testimony that someone may wish to offer fits under our rules of admissibility for experts? And so the next section, section C, 8, 9, and 10, says we have to include changing societal attitudes regarding the propriety of criminalizing the offense and the appropriate sentence for the offense. Are those societal attitudes in Springfield, Vermont? Or are they in Chittenden, in Burlington, Rutland County? In other words, are they Vermont or are they New England? You get my point. So it's very unclear what is intended here. And frankly, I can't think of any offenses that right now, and maybe Mr. Valerio knows of some, that would go from having at least a 15-year minimum that would be decriminalized. In other words, go from something like that to being decriminalized as it's the propriety of criminalizing the offense. And so we then get to line 12 where it says whether the petitioner was under the influence of another. I think I know what that means, but it's not really clear. Does that mean that they were directed by another? Does it mean that they were somehow influenced? Does it have to be direct influence? Or could it be an influencer online who they've watched and wind someone up or take someone down a road? Or is it more of a psychological influence that we know can occur?
Mm-hmm.
And so it's unclear what is intended there. There is, on page 9, it talks about medical records and reports from physical, mental, or psychiatric examination of the petitioner conducted by any licensed healthcare professional. If the petitioner is seeking to introduce records and evaluations for medical reports, is the state entitled to its own evaluation to contest that? In other words, if someone's saying, I've taken these evaluations, I have a low risk for recidivism, for reoffending, for instance, in sexual offenses. We have mandatory minimums of 25 years that have mandatory life in sex offenses. And so when we sentence those cases, we have the benefit of a psychosexual evaluation and a comprehensive pre-sentence investigation that the Department of Corrections is required to present. Are we going to have that? It doesn't appear so here. So if a petitioner says, well, I want to present this information, does the state have an opportunity? If, for instance, DOC has evidence in its records that says, no, this person hasn't really done well, does the state have an opportunity to get its own evaluations and its own medical tests? On page 9, again, it talks about line 7 through 9. Any evidence concerning whether the petitioner's original sentence was enhanced because a petitioner exercised the petitioner's right to a trial. You may not have your sentence enhanced because you exercise your constitutional right to a trial. And that would have been a subject, I would imagine, of a post-conviction relief if there was any evidence of that.
Mm-hmm.
That you had, as Mr. Valerio pointed out, a PCR is used to correct fundamental and constitutional defects in the sentencing, in the trial or sentencing of an individual. On lines 10 through 12, it also talks about evidence that the petitioner was denied effective assistance of counsel, including at pleas. But again, that's a PCR. That's a post-conviction relief. And so what this bill does is it blends the ability to file a statutorily provided post-conviction relief case with a sentencing. And is the intent to now have two tracks? Because if you look on page, I won't jump there now, but I can tell you on page 11 on line 21, it says nothing herein shall affect your rights to obtaining a writ of habeas corpus, which means that they hold your body illegally, or a post-conviction relief. And so are we now establishing in Vermont two tracks? One for sentence reconsideration that you can say, your attorney was ineffective. And what happens, for instance, if there was a case where in the civil division, someone filed a PCR for ineffective assistance and that was denied, and yet 13 years later, they come before the court and say, we want to try to get a benefit here. Are they precluded from arguing it in their resentencing if they're provided with one because they have already had a judge find that it didn't happen? Or is it because we have a different standard of proof in a sentencing for the admission of evidence? It has to be reliable information that you receive. Because we have that, can the court take it? And so these are the types of questions that I'm trying to I want to point out because these are what we will be wrestling with within the courts. And so it's critical to make sure that if you're enacting a statute that has significant consequences like this, that everyone knows what the rules are going into it. On page 10, on line 6 through 9, it says, if the court denies a petition filed pursuant to this section, the court shall make specific findings explaining the denial and shall set forth specific criteria for the incarcerated person or petition to meet prior to the filing of another petition. Well, any decision where a court denies relief should clearly and comprehensively explain why the court is acting the way it's acting. And the same as if the court grants relief. We should, through our orders, let not only the litigants, but the public know, here's why we acted and here's what we did. The question that arises here is, if the judge says, well, I denied it because of X, Y, and Z, and you have to do A, B, and C when you come back again, if you want to get the relief, is that somehow intended to bind the court? That we give the roadmap to say it was denied this time, but if you do A, B, and C, it will be granted next time. And so it's important to understand that next time they might not get the same judge. And so the next judge may look at it and go, well, I don't agree with that. I don't think that that was adequate. I would have ruled another way if I was the judge on that prior case. And so I don't know the benefit of saying that the court has to give a petitioner a roadmap. The court should have given, if you will, a roadmap for the petitioner in any event when they denied it and said, we're denying it because of the following reasons. That should be able to reasonably be reviewed and read by the petitioner as something to say, I need to work on this. As opposed to the court saying you have to do A, B, C, D before you come back. I could see an exception to that would be if the court said you need to successfully complete sex offender treatment before you come back, because under this bill, if someone, you can have, let's say, two individuals. One individual has a 25 to life sentence and he comes into the system and he participates in every program. He is a model inmate. He has successfully completed sex offender treatment. The Department of Corrections is having him work with other inmates because he's just done so much. And that person comes in at 15 years. You could also have someone who has not done any of that. No treatment, nothing else, and done poorly. They're both entitled to the exact same process, the exact same hearing. There's no threshold that has to be met. And so it's important to keep in mind that if this bill were to go forward, we will be having hearings. And that if we use the numbers that were up on the board, whether it was the 200 number or even I think the 147, that's a significant impact on the courts. We don't know how long these hearings will take. Will there be evidence? Will there be witnesses? We're not sure. There don't have to be under the bill, but certainly we would, as in the courts, want to make sure that the parties are given an opportunity to have a full and fair hearing. If it's a resentencing, there's a lot of factors that we had to consider at the time of the initial sentencing that are not present here. And so the other question that arises is, are the factors from Title 13, I think it's 7031, are the other factors that we have to generally consider with sentencing still relevant? So those are just some of the concerns that I had as far as implementation for the courts to make sure that if this bill were to pass, we understand what our obligation is to make sure that we do it fairly for all involved.
Do you have any issues with the language?
Other than that.
We're dealing with people's lives here.
And I would be remiss if I didn't point something out that I understand the policy that is sought to be advanced here. Am I allowed to raise this now? You know what I'm going to do? Several years ago, the Sentencing Commission made a recommendation to the legislature. It was Criminal Rules Committee. This is before I was chief judge. I chaired, and the Criminal Rules Committee also came up with this recommendation and also forwarded it. And I know Matt Valerio was in favor of it. Everyone was involved. State's attorneys, everyone was on board. And basically, under Vermont law, within 90 days of the imposition of a sentence, or within 90 days after the affirmance of your sentence in an appeal by the Supreme Court, you have a right to come back in for sentence reconsideration. And the judge can reconsider your sentence at that time. It's a limited right within a limited time frame. And back in 2020, there was a recognition that I think with the pandemic going on and what was happening was that it would be helpful if we had the opportunity and ability to possibly review some sentences that if the state and defense, if the victims who had input were on board too, and everybody wanted to say we should change this sentence, judge, and the judge was willing to do it, there's no mechanism for that to happen. And so there was a proposal that said any court that has imposed or is imposing a sentence under the authority of this title may, upon the stipulation of the prosecutor's office that prosecuted the case and the defendant, reduce or otherwise modify the sentence at any time after the imposition of sentence. And the thought was that you would have to have the prosecutor on board. They would have to obviously have victim input. The defendant would have to agree. Then you bring it to the court and the court would have to agree. And so if the court could say no at that point. But this was a solution to address some cases where people looked at them years later and thought there might want to be a change. And that did not go anywhere. And so if you're looking and the language of H379, if you say, boy, we want to help some of these cases where everybody agrees, you might want to consider bringing something like this back. And it was in the Sentencing Commission report that was filed with the legislature. And
What year was that?
That was 2020, and I can send the reference to it, but
That was unanimous with the Sentencing Commission?
my recollection is it was.
And why wouldn't it?
There's more history to that and more after that too, but.
As to why it didn't go forward in the legislative
Yeah,
arena?
there were other proposals that were akin to that were agreed to by the courts, by the Defender General, by the Attorney General, by the Department of State's attorneys and sheriffs, all at the time, part of Justice Reinvestment 2, that ultimately got torpedoed later. I mean, I can tell you all about it. I was going to tell you all about it when I get a chance to tell you all about it.
That's up next, right?
Judge Sunday will.
But he's,
mediate
bottom line is
the-
that there have been other proposals that get us somewhere on this issue. Maybe not as far as some would like, maybe, but we've had opportunities.
So, Judge, if there was that automatic 15 years, would that change the sentencing on the court's end at all?
I think it could.
The longer sentences?
I can't say whether it would go up or down, but when we sentence someone, we try to understand what the potential is for the future. But on one hand, I can say, yes, I think it may change. But on the other hand, I can say no, because the statute could change. And so the rules could change. And so you have to sentence with what you have before you on what you think is a fair sentence, not necessarily what you think the Department of Corrections is going to do or what may happen or might not happen in the future as far as legislation. So does it have the potential? Yes. Does it have the potential? And the state's attorneys, I'm sure, would have their view on this from my experience to say a sentence that otherwise parties may agree on with the knowledge of that that it's not really over. Does it have the potential to impact the ability of the state to enter into plea agreements? It may or may not.
And then what about if this should go into place and it doesn't take effect, the 15 years, time it starts counting is after July 1st, say it goes into law this year. It's anyone who is convicted after July 1st of this year. Everyone now who's incarcerated, this would not be available to them. It's only going forward.
It's a policy decision.
If I may, the way that it is written would apply to the current incarcerated population.
Yeah, that's what you were saying about the 100 on day zero, right?
Exactly.
Yeah.
And I believe there are some second look that applied now, and I think at least one or more states may have taken that position as a policy and said we're only going to be prospective.
Yes.
That's the determination of the legislature.
It's quite often when we change things within DOC's world, it's going forward. Now look back. Anything else for the judge before we put the Defender General on the hot seat?
Thank you.
Thank you.
Thank you very much.
Yeah, go ahead. It is. Open up the door.
It's cold in here.
Just open up the door.
Okay.
Yeah, here if we can.
We don't want me to hear what, you want to stay and hear what I say?
I might have to.
No, you can leave. I think that's a foregone conclusion. Well, thanks for having me.
Welcome. I don't know if you've been in this year. I don't.
No.
Okay.
You know, just for your record here, I am Matt Valerio. I'm Defender General and have been for a really long time.
Join the club.
We're gonna get some whiplash here.
I don't know, but you are going to get some history. I listened to what Judge Zone said, and I really don't disagree with much of anything he said. But I don't think it's necessarily the point. I will say this, I read through the bill. It really isn't well written, to say the least. It incorporates concepts that obviously come in from other states that aren't part of our statutory scheme or our legal culture in Vermont. And that's pretty obvious when you read it as someone who, you know, is immersed in that culture. But also as Defender General, I see what's going on around the country and the various issues that are being dealt with second look and resentencing statutes. Vermont is absolutely an outlier in not having some sort of review of sentences, particularly very long sentences. I don't mind if you close that. It doesn't bother me. But now that I don't have that jacket on, I'm much more comfortable. But and so we are odd in the fact that we don't have review of very long sentences for particularly younger people and people who have you know, as they age and the like. Medical furlough, all of these options, these sort of relief valves for sentences that were listed on the DOC's slide, they're out there, they're available. You know, to get like the medical furloughs and the like, you've got to be next to death before you do. This is not like it's not what many people might think when you think about a medical furlough, for example. When you're talking about people who are generally healthy, who are spending these very, very long periods of time in jail, there's limited ability, no matter what their risk level is at any given time, to actually release them. We don't have a lot of life without parole cases at all. There's such like that the 11 that we have, I could probably name off the top of my head 8 of them. And all of them are very serious crimes. And while I do think folks like that should have some level of review at some point in their sentence, they're not the ones that I'm the most concerned about. We have lots of people who have the 20 to life, 30 to life type sentences that are out there who have accumulated these or gained these sentences over a period of time. And some of them went in when they were quite young. You know, I know some that were teenagers who got 35 to life type sentences, and other people who were, you know, a little older, but you know, their risk level at various times in their lives are going to change. So forgetting about, and this is why I said everything that the judge said is right regarding this statute, but you've got the bill as proposed really needs to be rewritten comprehensively. And I don't know where, I know it feels like there's a lot of model stuff kind of being put into this place to get the issue on the table. The issue should be on the table, and we have had this issue on the table, and this is where I'm going to give you a little bit of this history. We're now in my 25th year in this job. I've seen this come up any number of times, but I'll give you the most recent 3 or 4. All right. Justice Reinvestment 1 with the Council of State Governments and Justice Reinvestment 2 with the Council of State Governments all contain proposals involving sentence reconsideration. There was a mutual agreement between the Department of State's attorneys and sheriffs, the Attorney General's office, the Defender General's office, and the then Chief Administrative Judge, who was Judge Grierson, regarding sentence reconsideration by agreement of parties in 2022. This arose out of what Judge Zone talked about, which was the Sentencing Commission's report November 23rd of 2020. And it was supported by also the court's the Criminal Rules Committee that issued a report 7/24 of 2020. The issue was also looked at by RDAP, the Racial Disparities Accountability Panel that still exists, in a report dated 6/9/22. So in the last few years, we've talked about this issue many times, and it's been looked at by professionals in the industry, criminal justice industry, and including victims groups and prosecutors, attorneys general, and the like, in a lot of different ways. Some with overlapping membership, some with discrete membership. And they all agree that there is a need to review sentences, particularly for long sentences, with certain criteria after a period of time. And whether it's 15 years or 10 years or whatever, I mean, the timeframes are, it doesn't matter. Choose a time frame. But once you choose a time frame, then there are other things that need to be looked at. And some of these criteria, there needs to be clear criteria, and other jurisdictions and model legislation that I've seen have clear criteria, elements that effectively need to be proved to allow for sentence reconsideration. These are alluded to kind of obliquely in some ways in the bill as drafted, but it's not terribly clear. But some of the things that have been looked at in other jurisdictions, they focus on what's the length of the sentence. They focus on the type and nature of offense underlying the sentence. You should focus on the age of the person at the time the crime was committed. There are also threshold requirements regarding the clinical age, mental age of the person. What are they suffering from? A mental disability while not incompetent to stand trial, but maybe suffering from a mental illness or a disability that impacts their judgment that at the time. There are a lot of the inquiry looks at what is the current risk level of the person. And there are risk instruments out there that have been validated that do this regularly. We do it for probation, we do it for parole, we do it in a lot of different ways when the Prisoner's Rights Office might be seeking parole or seeking or arguing about a furlough revocation or that kind of. These are validated psychological instruments that are out there, but they can all be incorporated into criteria. Basically, what we're saying is this person safe to release at this time? And that's a very different thing than what was their status when they were 19 years old and they were sentenced to 35 to life for first-degree murder. Where they're at when they are 40 years old could be very different. One of the things the details of this are not well fleshed out. in the legislation, in the proposed bill. And so I think that needs some work. That doesn't mean the concept is bad. It just means that we've got to do it better. It has to be written better. I think in these cases, typically around the country, it establishes a right to counsel and a right to appeal. When I look at what impact this would have on my operation, the Defender General's office, remember I wasn't in here to talk to. Most people are sort of the same as they've been over the years, but maybe I haven't been in here as much. My entire executive administrative staff in the last 18 months has totally changed. So everybody who's there is a year or been there about a year. That includes financial director, administrative services manager, human resources and program manager. All of these people are brand new. And so that's why I haven't been here. As much as I would love to be here pounding policy, I'm there actually making sure that they have some idea what's going on. And honestly, I didn't always know what all their jobs were, but that's why I wasn't here. But I know what was supposed to happen in general. But just to kind of review, my office has obviously all the staff public defense offices in the system, but we also have what I've now created is a post-conviction unit with 2 divisions. We used to have the prisoners' rights office and then the appellate division. And then traditionally, the prisoners' rights office handled post-conviction relief cases. But the prisoners' rights office is so overwhelmed doing medical cases, furlough revocation cases, and other conditions of confinement cases, plus investigations into deaths and serious incidents in the facility, that they are no longer actually capable of handling post-conviction relief cases. All right. And so I tried to streamline this by putting post-conviction relief cases into the appellate division. So it's now a post-conviction unit. What happens when there are appeals is they have to read all of the transcripts, go through all of the evidence and the like in preparation for appeal. So rather than duplicating that effort some number of years later in a post-conviction relief case, if the client wants one, we've already have people on that side who've already read the transcripts and have been through that evidence. And we don't know when. Post-conviction relief is one of those things that the inmates and defendants will file on their own. And then we look at it and review it for merit. Rather than having somebody who's never seen the case before do it, I put it in that side. Now that, of course, overburdens the appellate side. I will say this, that if we, right now, relative to post-conviction relief, if we tripled the size of that unit, okay, right now Prisoners' Rights has 4 lawyers, 3 investigators, and the appellate division has 4 lawyers and some support staff. If we combine them all together and we tripled the size of it, we still wouldn't even come close to being able to handle the volume of post-conviction relief petitions that are out there. And, if you remember, I'm going to have the chair flash back to the Douglas administration. Yes, you were there too. We had the Marks McLaughlin Commission that responded to 7 suicide deaths in 18 months. And there was a study that was done. And during that time, they doubled the size of the Prisoners' Rights Office from 2 lawyers and 1 investigator to 4 lawyers and 2 investigators. And while that was nice, it wasn't even close to what we were getting. We've done some things to try to eliminate frivolous claims from our docket, but all frivolous means, in the legal sense, is that it'll survive summary judgment effectively with the court. I don't want to go into the details of what that's about. The bottom line is it really didn't do much to stem the tide of what post-conviction relief was all about. And when I was first Defender General, post-conviction relief was about 26 cases a year. It's literally hundreds now. And when I was, like I go back to when I was a real lawyer for 15 years before I was Defender General, working in the field, post-conviction relief was kind of the extraordinary relief. There was something really wrong with this case, and we've got to dig into it. It was more akin to an innocence protection type thing. Now it has effectively become just the next step in the appeal process. And so allegations are made about ineffective assistance of counsel or jury misconduct or police misconduct or prosecutorial misconduct, judicial, whatever it is, the allegations come out and then you have to investigate them. And there are literally hundreds of those cases now, some of which are in litigation, some are pre-litigation, and a lot of them are just sitting there doing nothing because nobody can ever get to them. One of the things I think, as a matter of policy, that sentence reconsideration would do, and people do those things because it's their last kind of chance at appeal. If somebody had the right to reconsider their sentence after 15 years or whatever it is, I think we would significantly reduce the number of PCRs, and particularly frivolous PCRs that we had, because there would be, we aren't going to be contesting, did my lawyer say this, something else happened, or, was my lawyer not doing the right thing, or was the jury polluted by some information that they read on their phone during the trial as opposed to just listening to the evidence. And that's the kind of thing we get, right? They wouldn't have to contest like all of these things, and they would just say, look, I have a chance to show that I've changed in the last 15 years, and this gives me a chance at freedom at some point, right? And that's what these second look laws do. They give people hope that at some point, if they do the right things, if they get them, even if they just age enough. I mean, we can look statistically at when does crime for males start to precipitously drop? Age 41, 42, right around that stage, and so if you come in as, hot-headed 20-year-old and now you're 41, well, you aren't the same person biologically, and the development of your mind is not the same. I don't want to, I've read all of those theses. I understand what that's all about, but I'm not a psychiatrist or psychologist or sociologist. But fundamentally, we know that. So it makes sense that at some point we're going to look at what is the dangerousness of this person now. This could be a benefit to my system in that we won't have to deal with post-conviction relief cases that are just marginally able to get over the issue of summary judgment because it's the last thing that they've got going on before they serve life without parole, or 50 to life, or 35 to life, or whatever it is. If there are clear criteria about what a court is going to consider and who has the burden of proof and what that burden of proof is, and the like, that would improve this bill 1,000%. The other thing is, just because you have a right to it doesn't mean you're going to get it. The court is a backstop. I don't know if you've noticed how many prosecutors have been appointed to the bench over the last 20 years or so. I could tell you how many public defenders have been, and I can count them. Well, then, no, it's not zero, but I can count them all on this hand. How many judges are there now?
40.
Yeah, well, if I can count the public defenders on this hand, that means there's 35 others of them, and I don't think there's 5. There's some who did some public defense work, but staff public defenders is 1. And the last one before that goes literally back to the Dean administration, who, by the way, was the guy who appointed me the first time.
And you've been with us ever since?
And I've been with you ever since. because I love the job. And the point being here is, don't throw the baby out with the bathwater, because this bill isn't written particularly well, and I agree with the judge totally on that. The concept is right. And it has uses that I don't even like making the argument that it saves money, because I don't really care. Does it save work for the Defender General's office? I do care about that. And is it fair to people to judge them at 40 the same way they're being judged when they're 20, and they made a decision, and many decisions, some horrific decisions? Are they the same person? I don't think that's right either. So we understand that when we sentence people, the concepts are, we sentence people for deterrence purposes, to deter other people from doing these things. A lot of the crimes that result in these kind of sentences, you're not deterring anybody, so don't worry about it. You sentence people for rehabilitative purposes so that they can get some kind of treatment or whatever is available to them. And you sentence people for punishment. And a lot of these sentences are really about punishment, because you're not even eligible for treatment in the Department of Corrections until you get to, is it 18 months before your proposed release date? They aren't even going to start, if you do a 15-year time frame and someone has a life without parole, or they got a 50 to life sentence, they're not getting programming. There are certain things they can participate in along the way, maybe some education, they can do jobs in the facilities, but they're not getting the type of treatment that everybody's looking at, because they're not even eligible for it. Doesn't mean they won't change. So if they are evaluated, and if the Defender General's office, through its post-conviction relief unit, is going to be handling these cases, which I assume we would be, because by statute, we represent everybody who is under the custody of the Commissioner of Corrections, under whatever status there is, then we're going to look at what is their risk today at 15 years and 1 day, or whatever it is, whatever we can do at the time, or 20 years, or whenever we decide, whenever they can do it. And we're going to look at whatever other factors, mental health issues, and disability issues. And, one of the things, I hate to say this because it might be inflammatory, but whatever. A lot of times in murder cases, and I handled a fair number of murder cases when I was handling cases in trial level, the person they murder, if someone committed one, that's their problem. Like, their risk to somebody else is almost none. Some of the easiest clients I ever dealt with were my murder clients. Whatever happened, and they have great remorse. They have, whatever was going on that led to whatever that horrific time was that was the murder. Even at the time of sentencing. Now, we understand there's got to be punishment, but there's got to be these three concepts of deterrence, and whether it's real or not, all of these things. This is part of our culture, part of our history, part of what criminal justice is all about. These have to be satisfied, but their risk to the public after this is negligible, if any. That having been said, they're going to have to serve some time if they're convicted. By the way, not everybody who gets charged with murder gets convicted. Lots of acquittals, to be honest, or dismissals, or other things. That having been said, that we're talking about the people who were convicted. So down the road, is it fair? Is it right? Is it a legitimate thing to do, to look at whether somebody is a risk to the public and whether they need to be incarcerated at, I guess they say $299 a day. I had a number somebody gave me of $137,400. I don't know where that came from. But,
That's a bit.
But
this is 109,000 if you do the math on the 299. But whatever, it's a lot of money. Literally, we go back 5 or 6 years and it was like 60,000. So it's going up like everything else. Is it worth for someone who's not a risk to the public to be taking up that bed at 109,000. You know, like they say, you can put them on a Disney cruise for less money, for a whole year for less than 109,000.
That's cruel and unusual. You can't-
Yeah, I know, too many stuffed animals and stuff. The point being, is it legitimate to look at these things? Of course it is. But this bill does need to be reworked, so it's actually doable. In the interim, we could definitely take a look at Senate's reconsideration under Rule 35, particularly where there's agreement of the state and the defense being involved. And this actually, not only the proposal that the judge talked about, this passed both sides. And it ended up dying in conference committee, I believe, or it was referred back to the House, because I know it came out of the Senate and I know it came out of the House Judiciary to begin with. But the Department of State's Attorneys and Sheriffs had a position. But there were 3 or 4 state's attorneys who didn't like it. And they lobbied contrary to their department's position and basically killed the bill at the time. Now, they have every right to do that, and there were legislators who went along with it, and the bill died. This is politics. You guys, I hear you playing this stuff. But the concepts were really by the people who did all the studying, who from the Sentencing Commission to RDAP to the Rules Committee, everybody agreed that this was the right thing to do. At the very least, this is something that could be done relatively quickly and looked at. Now, I don't know if anything gets done relatively quickly, especially, there's not real crossover right now, but it could hang on till next year and you can figure it out. In the meantime, maybe a more coherent proposal with the very good concepts that are in this bill could be worked on. And that's what I'm hoping that you do, is that you don't throw the concept, like, they say the baby out with the bathwater. Don't throw a very good concept out because the bill's not particularly well written and doesn't incorporate our Vermont institutions and culture with it. That's really, I'm happy to answer any questions, but that's really what I had to say about this. It is not I don't even know, on the federal level, we have second look. Donald Trump signed second look in his first administration. I don't know what that means, but he did.
He needs to.
One of the big proponents of it, oddly enough, was Kim Kardashian. Yep. Actually was the one who helped push that bill through. In any event, that doesn't mean anything either.
So just for clarity here, Matt, was the reconsideration proposal, it was never adopted in the Vermont rules, criminal procedure 35, or was it?
It was not. The judiciary didn't do it. The judiciary didn't do it on its own.
It wanted
Could have.
statute, right, but it wanted statute to do it.
But
We didn't because at the time I had the dual role of being chair of the Sentencing Commission and chair of criminal rules. And so we didn't do it and pursue it at that point because the statute didn't allow it.
Right.
And so we didn't want to adopt a rule that could not go forward.
You still would need the statute even now to adopt it as the rule.
Right.
Okay, just wanted to be clear.
Yeah.
John and then Kevin.
Judge or defender?
Defend.
some people just call me general, but most call me Matt.
Defender general. He's defender. He's defender
You were
general.
talking about, so it's more of it's the nuts and bolts. So you were talking about it was going to be challenging though so as good as this is, can you handle all that extra work?
I think it'll reduce our work.
Or reduce it.
Oh, really? Okay.
Because I think it'll take a significant number of post-conviction relief cases where there are marginal allegations of ineffective assistance of counsel or some other stuff that, because it'll survive summary judgment, because there's a dispute of fact, we still have to do the case. But if people know they have another outlet that is much more legitimate and much more able, then we will reduce those post-conviction relief cases, because right now it's the only way that they can see freedom in some way potentially. And a lot of those cases we have to do, but they're really, really bad. Like there's no chance in hell we're going to win them, but we have no choice but to take it. Even, when we have the right to reject some cases, but they have to be frivolous as a matter of law and meritless as a matter of fact. They have to be both. And we can reject them under those terms, but if they come up, one of the things that happens is the defendant will come up with a lawyer who will say, "Oh no, I think that person was ineffective," and then now it's game on. You got to take the case. So they're all expert-driven cases. These are going to be cases driven on risk. That's what's going to drive the whole thing. And we have validated instruments to measure risk. And that's the big difference. We don't have to rewrite history. We don't have to say, oh, what my lawyer did over this 2-week trial was garbage. Even though, we've already lost on appeal. Now we're doing PCR. With this, we can say, we don't have to worry about that. We have to worry about where are you now as a matter of risk. I'd much rather do that case. And I think that anybody who's looking for potential freedom in their lifetime would rather do the good case, not the one that's never going to win.
Kevin?
So this was fascinating. So how do we get to the criteria everybody could agree on to streamline and do the job? How do we do it? Do we look at the federal guidelines?
You can look at federal law. There are model statutes out there. Some of these, by the way, and I see it incorporated into the bill that's drafted, were drafted around drug crimes that ended up with really long sentences, life without parole. Like the judge talked about failure to accept responsibility by taking your case to trial. That is not a Vermont concept. In fact, it's illegal in Vermont. That is something that's part of the federal sentencing guidelines, but it has nothing to do with Vermont. That failure to accept responsibility by going to trial, that's not a thing. So we have to weed out the parts that are not relevant to Vermont, but there are model statutes out there from any number of states that allow this sort of sentence reconsideration. We just have to find them and list the ones that are relevant to us. I mean,
now this is editorial. I would think if we got that list of criteria, but then have the caveat that if they're a repeat offender within a period of time, that would satisfy both sides of the coin.
Would be. I mean, a lot of people are repeat offenders.
Well, but if they're a repeat offender, it means that the risk assessment wasn't accurate.
No, you're talking about the past. I'm talking about the present and the future.
They might have offended at 18 and 21.
And they might have been on probation.
I know, but
You're talking about.
But if they get out and they repeat offend.
Oh, well, there's a new crime. We'll deal with that.
Exactly.
We'll deal with that, and if they are, and then they're resentenced on whatever. We do that all the time. I mean, we see people, 80% of the people, if the stat still holds true, I just repeat things I've heard for 24 years. 80% of the people who come into corrections come in and go away and you never see them again.
Yeah.
And then there's 20% that seem to recycle constantly. And so, and then you hit that age when their criminality drops off the table.
So Matt, I'm just trying to think how to keep this conversation going. It's the end of a session.
Yeah.
A few more weeks left. Sentencing really isn't in our jurisdiction. It's House Judiciary. And I'm just wondering how best to keep this conversation going.
Well, God forbid that there be a study committee.
Well, I'm wondering, I know.
But
Justice Oversight could do some work on some of this.
well, it could, but
Maybe.
honestly, this is where, with all due respect to Justice Oversight, this is where the professionals should be charged with studying this and coming up with a proposal. Not that you're going to do it, But that if you were going to do it, this is what it would look like.
Yeah.
In Vermont, not, not the feds, not Illinois, in Vermont. This is what it'd look like.
So do you want to bang this out this summer and get it to us, next?
It's, I have people.
That's all we need. We need the people.
But, it is something we could do and everything that this kind of thing, it has to go through me and we've got folks who are going to advocate for certain things and I'll say, well, that's not realistic and you got to trim this down or whatever it is. I'm sure we could do it, but us doing it unilaterally, that's not going to fly just because it's us.
Gotta have all the parts.
Even if we're totally reasonable, it wouldn't fly because it's us. But it's better if we do have a group of representative people
So I wonder if.
and looking at Rule 35 as well.
Right, so I wonder, I don't want to lose this, I'm just trying to figure out how we can go forward with this, and I know we have state's attorneys who are here on Zoom that we'll have to reschedule, because we're really getting too late in the day here. But I'm wondering if some of you folks could get together and kind of brainstorm in terms of who could do the work on this and come back next year with a recommendation.
You'd have to create a study committee of state's attorneys, Defender General, Attorney General's office. You're probably going to want a victims advocate of some variety involved in it. The center and the network. I think though that it has to be set up in such a way with it, if we were going to do it, not that we are going to do it or you have to do it, but if you were going to do it, what would it look like so that it would work in Vermont?
Yeah.
How can we put something together, language together really quickly in a short period of time when we're not really the committee of jurisdiction, it's House Judiciary? Would it be worth it for the two chairs of a committee to sit down with you folks and kind of work through some language?
What, to do a drafting committee, a study committee of some
Yeah.
variety?
Tack it on to S-109.
Is that miscellaneous judiciary bill?
So you can't.
Everything else goes in it. Why not?
I mean, you can't start with a new bill at this point. It's not going to make it.
No.
And unless you do a resolution, to pass a resolution.
Yeah, but you've got bills out there that you could do this with as an amendment.
Yeah, but it's not in our jurisdiction, it'd be judiciary, but I'm just
You
wondering.
know that guy.
We know that, but I'm wondering if it's something that we could quickly put together. State's attorneys, you folks, Martin and I. Let's do something.
We did it with Rule 35 5 years ago.
Right.
And it was actually even before that, because this issue's come up some number of times. Over the years, and it's legitimate because it
It is legitimate.
but it's.
But let's do it the way, Vermont way.
Yep.
So maybe let me reach out to Martin Milan, see, because,
I'm happy to talk to him
Yeah.
whenever we need to.
Yeah, and see if we can put something together real quick.
Right.
Check on, does that make sense to the committee?
100%.
It always does. I appreciate you giving me the time.
Thank you, Matt.
Appreciate you
Good to see you. It's good to see you in the building.
Thank you for the information and the laughs.
And we'll schedule in the state's attorneys too, because they've been on Zoom.
Are your circumstances going to be better that you'll be able to be out of your office?
I think it's going to get worse.
Your
before it
testimony
gets
is
better.
talking more about the concept, because if we get bogged down, on it,
We're getting into
like everybody else does, we'll be spinning our
No,
wheels,
it's
I
just a
think.
concept, just do.
Thank you.
When state's attorneys, this concept,
Yeah,
right?
it's just a concept, this.
Yeah.
Okay, anything else before we finish up? So tomorrow we're back here at 9:00. We do have something on our schedule at 9. We are here at 9. And
What did you say it was gonna be?
It's Alexandra Bailey, who was supposed to be with Dr. Reese last week, but was unable to be here.
So it's about this.
It is
Good
about
enough.
second one.
thank you, folks.
Does it still make sense for Alexandra to testify, or because she'll roll with us on, the decisions? So what do you think?
I think we're taking a different direction.
I know, it sounds.
So I'm kind of thinking not to do that.
We also have Jennifer Pullman, who's emailed me and said that she would give up her time tomorrow at 11:30 for the state's attorneys. So I don't know, Kim, are you still on? Do you have the ability to testify anytime tomorrow?
Hi,
Hello,
Kim.
everyone. Hi there.
Do you have time to testify at 9 tomorrow?
Unfortunately, I'm already double booked at 9 a.m. tomorrow. So I
Okay.
think that triple might be pushing my limits. So
Are
tomorrow
you
morning-
able to do it?
What about 11:30?
Would Jennifer Pullman be able to do 9 tomorrow? What is she coming in on? She's coming in
She's coming in on.
379.
9, yeah. I don't know that yet.
Could you make 11:30, Kim, tomorrow? And what we'd be talking about would not necessarily be what's in the bill of 379, but the reconsideration proposal that the Judge Zoney and Defender General just talked about if you're gonna do a reconsideration of someone's sentence, imposition of their sentence, what is that criteria you really need to look at? Would you be able to shift gears and talk about that at 11:30 tomorrow?
Mm,
No?
Possibly. I mean, I would be able to speak to it in a technical, general fashion. I would in no way be able to represent how our department felt about it at this time. So I could touch on it. I don't know when I'll be done with House Judiciary. Tomorrow I'm scheduled at 9, but I'm the 4th witness. And it's on the sealing bill. So I could tentatively be with you all at 11:30, but I'm also not entirely in control of my schedule
Right.
tomorrow.
Are you in the room tomorrow? Physically in the room?
I am, yes.
We're just down the hall from them, not far. Why don't we
2 doors down.
why don't we tentatively think of 11:30? And if you could give that real broad, I understand it, the real broad thinking, thoughts, overview on it.
Yes, I could be incredibly
will-
broad, and if you could be
Yeah.
incredibly flexible, knowing that I might need to say I'm not available. I have a hard stop at noon because I need to go to
Yeah.
the police academy for the afternoon. So tomorrow's tight, but I'm happy to come in at 11:30 if I'm available.
Try that. Let's, and see if Jennifer can come in at 9. I know, but it's on the bill, so we've kind of taken a different direction, but at least have a conversation with Jennifer Pullman on the victims piece. Okay, so plan on being here at 9 o'clock. We'll fill in something somehow, one way or the other. Thank you, Kim. Thank you for your waiting in, and hopefully tomorrow can work out. That.
Great. Would be wonderful to meet you all in person. It was unfortunate that I was going to meet you today for the first time. So remotely, maybe it works out that I get to see
Maybe
you all.
it works out. We're just down the hall, 2 doors down.
We're very nice people.
Kevin?
I would assume, so I'm gonna ask, is there not criteria for parole and furlough and medical?
Mhm.
If we started with that, because we're gonna
No.
come up with another set of criteria for second look, wouldn't that be a logical way to attack this?
Haley was shaking her head no.
Kelly would shoot you down before you were finished your thought, Kevin.
like daggers.
I guess I wasn't sure if you were referring to changing the criteria that already exists for furlough and.
No, looking at that as a basis that I would reconsider.
On my head.
I'm just suggesting if we know those 3 different criteria, there's no point in being redundant. So there must be a 4th set of criteria for second look, which basically says, is the person still a risk?
The professionals are gonna work.
Yeah, they're gonna figure that out.
We can do that. It will take some time because those can be quite lengthy to go over our policies as they relate to furlough. It's multi-pronged. Take It will just slow you down a bit.
But it's not us,
For policy, I'm
But
looking
it's
for.
a starting point,
Criteria.
but it's not us that's gonna do this. It's
Oh, I
going
understand.
to be the
It's going to
state's
be-
attorney, defense counsel, the judiciary, the victims group. That's what they're gonna look at in terms of what is the criteria for the reconsideration.
Our criteria is to set them up. To tell them to do it, ask them to do it.
Okay, 9 o'clock tomorrow morning, folks. We'll figure out something.